Nothing is the same anymore. Everything's changing. I really can't explain what I'm seeing when I look outdoors. Society is falling. Mother Earth is calling. How much more pain can she endure? I will need you more than ever before. I believe you. I believe you. Yeah. I remember when children used to go outside and play. Nowadays, when you see them, the phone be glued to their face. Am I tripping to do it? Seem like humans losing their way. Families are dysfunctional. They don't even fun no more. Our elders used to be wise, but now they under my control. Glued to the program instead. I meant TV. Nothing is the same. Not even the food we eat. Fluoride all in the water, making it hard to stay. To be honest, it feels.
Listen, because you are that, you are capable, you are gifted, and you are soon to be opinionated. It's okay to be different, and it's so okay to just be you. The world awaits to receive you.
All right. Blessings, blessings. I didn't know I still had my picture up there. Blessings. Welcome to Uncensored Enlightenment Talk. Yes. And today we're going to be doing an update. I don't know if you guys remember, shout out to all of our subscribers. You know, I try to keep things diverse. A couple of months ago, I've been sprinkling in Atlanta. Okay. We got a whole section for Atlanta news and highlighting a lot of what Miss Fani Willis has been doing to allegedly destroy Fulton County's judicial system, the jail, and everything above. So what we're going to do today, I was like, okay, I think this would be good for our audience because you already know what Grace Levi is going through. I've been doing a lot of freedom of information requests, and sometimes I have gotten stunt and had to move on to another level. So in this particular broadcast, we're going to show you the hearing after Fani Willis was already made to release certain documents related to Georgia voting registration. And we saw that together. Now, this is another lawsuit that is a continuation that has been going on for a while, highlighting, let me just get their name real quick. And Judicial Watch, okay? Because I was looking into two places. So we're going to introduce you to Judicial Watch, as well as later on we're going to show you the Institution for Justice. It's the reason why we're putting that up there, because I think that these two nonprofit organizations are going to be really busy this season in this next up in 4 years, because you already know a lot of our protections have been dismantled. All right. So if you don't know, just before we get to that, we're going to start it. I just want to get into this. Fani Willis, this is how belligerent she is. Okay. So the hearing where it was about her and her boyfriend, and the alleged inappropriate use of funds and putting him on the job as the top prosecutor and all that stuff. Now, Judge McBurney was a little bit soft on her at that point, but at the end of the day, she is to the point that she has been disqualified to investigate Trump in relation to that. So, Fani Willis seeks to overturn her disqualification from Trump's Georgia election case. So they didn't overturn the case and say, hey, it ain't going to be no case. But she's off of the case, as well as her boyfriend is off of the case. So this was January 9th. And she already said that she was going to, contest it and things like that. So what's so crazy is that she's still reiterating these same sentiments now. Okay. So here, this is Fulton County District Attorney Fani Willis has asked Georgia highest court to review the lower appeal court's ruling that removed her from the Georgia election interference case against Donald Trump and others. The Georgia Court of Appeals last month ruled that Willis and her office cannot continue the prosecution, the case, because of the appearance of impropriety. And this is improper. We already know it's a conflict of interest. It's not an appearance, but this was a nice way to put it. Okay, so related to her romantic relationship she had with special prosecution Nathan Wade. Okay, when she had hired to lead the case in this petition filed late Wednesday. So this was January. Willis asked Georgia Supreme Court to review and reverse the decision. So people like whatever. The election came. We know it's not going to really hold no weight, but it's so crazy because again, we're in February. We're in February, and again they reporting, and I'm like, why are they reporting this again? Because she must have followed up with a letter or something, but it did put it back on our radars that she is still to this day, even though Trump is in the office, trying to prosecute him. Okay, now I don't know how this is going to work, but we're going to listen to this, and then we'll read an article of some experts that say, like, basically the outcome if she does get to move forward. Just a hot mess. Belligerent.
In a new court filing, Fulton County District Attorney Fani Willis is renewing her request for the Georgia Supreme Court to review a lower court decision that disqualified her from the prosecution of President Donald Trump. 11 Alive Zach Merchant got a copy of the DA's court filing. Zach, you're joining us now. What more do we know about this?
Well, this is just the latest step in a long legal saga that is still far from over. In a brief filed Friday, the DA is once again arguing that the appeals court that disqualified her from that 2020 election interference case got it wrong. The case bogged down in January of last year when defense attorneys argued Willis should be removed from the case after it was revealed she had shared a romantic relationship with special prosecutor Nathan Wade. She defended her conduct and said the relationship never impacted her work on the case. But a Fulton County judge ruled that the relationship created what he called an appearance of impropriety that could only be fixed if one of them left the case, and Nathan Wade soon resigned. But a majority of a 3-judge Court of Appeals panel later found that that decision did not go far enough, and they ruled that Willis and her office must be also disqualified from the case. Now, the district attorney has pushed back on the rulings from the start, and she's now urging the state Supreme Court to intervene. The court has not yet indicated whether it will accept the case or not.
And Trump already got the Supreme Court, but just as far as weight. But let's just finish. Listen, I mean, this young lady is belligerent. Let's finish.
And Zach, it doesn't seem like the district attorney has any plans on giving this case up at all. This has been a long-running legal battle. What is the DA's argument?
Well, look, these are long briefs, a lot of legalese in these court documents, but essentially DA Willis is arguing that the Court of Appeals got the law wrong in their decision to disqualify her. They wrote, or rather she wrote, that the Court of Appeals deployed what she called an utterly novel application of the law, and she is now asking the state's highest court to take a fresh look at the ruling. All of this litigation, it's important to note, has had a big impact on the underlying case. While the disqualification question continues to work its way through the appeals process, the Fulton County criminal case against President Donald Trump and others has been effectively frozen.
Yeah,
it hasn't been dropped. It's been frozen, highlighting that this man is still the president. Let's put it on a screen. We got a lot of hineyards. We got a lot of belligerent politicians out there anyway. So according to Yahoo News, even if the higher court eventually rules with Willis' favor, it seems unlikely that she'll be able to prosecute Trump, who returned to the White House January 20th. But there are 14 other defendants who still faces charges. So I think she's trying to move this like a racketeering case. And if we have to go through what we went through with the YSL case, as you watch, Fulton County prosecutors literally piece the case together. Some of the things that we talked about when we talk about running just a general case, even if it's civil or criminal, there's a series of hearings and motions that go through before the jury is set. And those motions and hearings deal with the evidence exchange, how things are going to break down, because both parties have to be transparent. And that is not how Fulton County run. So a grand jury in Atlanta indicted Trump and 18 others August 2023 using the state anti-racketeering law. to accuse them of participating in a wide-range scheme to illegally try to overturn Trump's narrow 2022 laws to the Democrats, Joe Biden. All right, the allegation includes Trump call to Georgia Secretary of State Brad Raffin Springer, urging him to help find enough votes to beat Biden. So, with that type of talk, he even for allegedly they to have that, if they have any type of communication, this is how wide range and how can I say broad the racketeering charges can be brought. So by him saying, find me some votes, this will indicate to them that they're trying to make votes up, which, is ridiculous. So there's a lot of legalese, as they say, they put into these documents to make, I would say, the common person confused and add a lot of more to it so they can get through things when the case becomes president. She is the type of person you need to watch out for. She's the type of person that will move like a Keith Price. You know how Ted Keith Price was, where he's going to find some type of angle. So she literally said, the judge, the jury, and everybody didn't get it right. Let me tell you the law. So this is kind of like back to the background of what's going on with Fani Willis, to get a little update because we haven't been talking about her too much. But moving forward, this continues. Her antics continues. We ain't gonna talk about the jail. We ain't gonna talk about the jail today, but we're gonna have to do an update on Fulton County Jail, because the last thing that I looked up that they were supposed to be transferring the prison is out. And I tell you, when we go look that up, they better have that jail empty, even though I know it's not. I'm just talking crap right now. So what we're going to be watching is the hearing on the motion for in-camera review of freedom of information request made by Judicial Watch. Okay, and this freedom of information request consists of some part or all of some of the exchange of text and things related to spending. I think basically it's the same thing that they were going after her before, for the case. This is what this actual freedom of information request is asking for. So because all of that wasn't brought out in the case because of the hearing and the judge's, opinion and, what he said, basically, Nate and Wade get off of it. They didn't have all of this information. And I believe that Judicial Watch and many other individuals, from what I'm hearing, that is other content creators, people of the community as well, because want this information. So to give you a heads up, Judicial Watch works at like a nonprofit entity that basically, it said Judicial Watch is a nonprofit entity group that files freedom of information request lawsuits investigating claims, misconducts by government officials. So they were founded in 1994. Judicial Watch has primary target Democrats, and particularly the administration of Bill Clinton, Barack Obama, as well as here. Now I'm reading this off a little actually that's judicialwatch.org. That's their own website. So that's what they had said. So we're going to keep Judicial Watch under our radar. I'm going to put their website up there so y'all can see. It's a little busy, but it's okay. We'll take it because we may be having to call Judicial Watch to get the rest of our Alexis information. You know what I'm saying? Because the Illinois State Police not working with us. So this is some resources for everybody, especially if you're filing freedom of information requests and you need a little bit of support. You see what I'm saying? So this is Judicial Watch. I'm going to leave the information down there. You get to know them, but we're going to look at the hearing that they're having. They had 3 days ago. I do apologize. It was 3 days ago. So I had got wind of it. I was like, oh, snap. Yeah, let's get to it. Now, this is one more nonprofit institution that I do want to make y'all aware of. And I was made aware of this because, I told you guys that I was going to report the speed zone out here, the school zone, and when I was doing my research, the Institute of Justice for Justice already has their eyes on the speeding tickets that's going on out here and in other states, y'all. So I said it was very important for y'all to get to know who the Institution for Justice. It's a nonprofit entity, public interest in law firm. Our mission is to end widespread abuse of government power and secure the constitutional right that allow all Americans to pursue their dreams. So we're going to get into them on a later date, both of these entities, to see how they'll help us, help us, the community, because obviously we're going to need some other resources outside of my favorite division, community protection. Okay, even when you sometimes write a letter to the attorney general, they will ignore you if you don't have like the Consumer Protection Bureau CC'd and things. They kind of know you're not playing. So we're going to leave that information down there. I want y'all to search their page. They may be able to help you with something. And even if they don't have what you need, you make a call and they can give you some resources. So now what we're going to do is get to the hearing, and we're going to listen to the hearing. And I think it's still like so important for us to listen, because Grace Levi may be in Illinois, though. I'm not about to play. I'm supposed to be going. Hold on a second. Things kind of froze a little bit. I apologize. Going over a lot of the freedom of information requests that I have made, doubling up, making sure everything is good. Still things are pending. So I'm looking for resources like, okay, what are we going to do? Because I ain't got $1 million right now, but we're going to have to keep this going because, time is everything. Administrative process is everything. So let's watch this, get some key information. We're going to let it play, and then you guys can get into the audience and say what you need to say. Definitely, because when we get into these freedom of information requests, we may be able to help a lot of people, because that actually divulge a lot when you don't have subpoena power. So let's play it. And shout out to everybody in the audience. Shout out to you, Jerry. Thank you for being here. Hold on.
Myself. Why don't we get 2805 Judicial Watch versus the District Attorney, Ms. Willis, and we are here to talk about next steps in the case. This case was brought when the District Attorney's Office, I found, failed to comply with an Open Records Act request that Judicial Watch had filed. And we've learned a fair amount about the efforts that were and were not undertaken by the District Attorney's Office to comply. And we reached a point where I entered an order that set a deadline for the District Attorney's Office to actually do what it was supposed to do a while ago. And in doing so, the District Attorney's Office identified a universe of documents that would otherwise comply with the request, or were responsive, I guess is the way to put it, responsive to Judicial Watch's request. But the District Attorney's Office contends that those records or documents are exempt or accepted from production under the Open Records Act because they pertain to an open investigation, or they're privileged, as in attorney-client privilege, and or they are attorney work product. Mr. Monroe, on behalf of his client, has filed a motion for an in-camera review of those records and or the appointment of a special master. And representatives of the county attorney's office representing the district attorney have expressed their view on what the right response is as to where we are. And I'm happy to hear from both sides now. I'm going to start with you, Mr. Monroe. But let me tell you what my initial thought is as to how we handle this. I think I can appoint a special master. I think that Rule 46 empowers me to do that. I appreciate that the Open Records Act doesn't speak to it, but it certainly doesn't prohibit it. And there's nothing in Rule 46 that says special masters shall only be used in situations outside the realm of the Open Records Act. But that's an expensive proposition. It would be an expense borne by both sides, not just one. And I don't know that it's necessary. And that's what I'm going to want to hear about more. In a little bit, you're doing some shadow boxing, Mr. Monroe, because you don't know what's out there. And I think that's part of your client's concern. But my initial thought was that I hear, and it may not be that I hear in open court on the record, but that I receive information from the district attorney's office through counsel for the district attorney's office about what that universe is. And if it's 55 pages, we don't need a special master. I can do that. If it's 5,500 pages, I'm not looking at 5,500 pages. That I will, but I'll get that done over the next 4 years. And that's not helpful to anyone. So we would need a special master because she or he could devote the time, because she or he would be getting the money to devote the time. So that seemed to me like the first hurdle is, well, let's figure out really how big this universe of potentially exempted records is, how big it is. That doesn't address, though, your concern. That's why I want to give you the voice in just a moment of, well, that's what came up when they really searched, when you told them they had to. But what about Mr. Bond saying, I didn't look in people's cell phones, I didn't do this or that? Then I would be reviewing an incomplete universe. So we'll need to work through that. I'm not sure I'm going to be telling anyone they have to hand over their cell phones, but I am going to listen to you about what you think ought to be done. But I don't mean to get ahead of myself. Why don't we get the entries for the two sides on the record? I know we've had a little bit of a rotation on the defense side. So on behalf of Judicial Watch, we have
John Monroe, Your Honor.
And on behalf of the district attorney, we have
Good afternoon, Your Honor. Brad Bowman.
And Deidre Thomas.
Hi, Ms. Thomas. Hello, Mr. Bowman. Before we dive into it in the way I described, is there anything procedurally, Mr. Monroe, you want to go over?
May I remain seated so I can stay by the microphone, Your Honor? Is that all right with you?
As long as Ms. Taylor can hear you, I'm fine with that. Let's make it easier by adding you, and you can move the screen around if you want to be more centered in the screen. And then we've got a screen with the lawyers for the DA on there as well. So Ms. Taylor can see all that. And she gets the bird's eye view of the courtroom. So you can stay right there. Procedural matters.
I'm not sure, Your Honor. I just want to point out, I think this hearing was noticed for both the in-camera inspection and or the special master appointment. I'm not sure what we can do today about the in-camera inspection, because one of the issues we have is there wasn't a privilege log or anything else associated with it. I suppose that the defendant could just hand over everything they say is responsive and you could sort through it. I think that would probably be doing a disservice to you if they didn't start by at least identifying what they have. And as they pointed out in their brief, one of the things that could be done is a hearing to determine, based on their description of what they have, whether it might even qualify, because we might.
That could be done. I don't know that it has to be done. And I'm not interested in compelling the district attorney's office to describe things, especially where one of the categories is open investigation. So I'm very comfortable starting the way I described, and I didn't mean to suggest if we mislabeled the notice for this hearing.
I was mute. Thank you, boo. I'm so sorry, and I probably went in for a few minutes. I'm gonna stop muting that button. I don't want y'all to hear. What I was saying, what gets to me is ridiculous, is the fact that they already won the paperwork already. They won the case. And the basis of them winning was that Fani Willis' office was saying, oh, we don't have that paperwork. It doesn't exist. Oh, well, we have some paperwork. And, we have some phone. We don't have this. But the judge know that something exists. So I'm just saying he's extending himself a little bit too much. And that's when we talk about the politics. He's been a good judge. And thank you so much. Okay. Miss KJ, I appreciate you. He's been a good judge, but I do think he's making this play out just a little bit too much. He should compel her to bring everything out, produce what she needs to for the Freedom of Information request, redact what she needs to, because it's already in the law. It's already in the law. So this is just extra, basically what I was saying. But I want to listen to it so we can learn a little bit more. I appreciate you guys.
Today is not the day for the in-camera review. Today is the day where we talk about what's the next step. And I have fronted my view that what I see as the next step is for Mr. Bowman and Ms. Thomas to get to me an overview of this is the universe of the things that were withheld. And to me, I'm much more interested in numbers rather than descriptions, because if the total universe, to include things that the district attorney insists are privileged, is 12 documents and the page number is less than 100, I can go through that. I can figure out for myself what I think ought to be disclosed and not. And then we can go through a very common exercise is just outside the realm of the Open Records Act usually, where then I would get back to the county attorneys to say, I think these three things should be disclosed. And they'd have a chance to push back, say, here's why you misunderstand. And then ultimately you're brought into the loop as well. But I think necessarily there may be some ex parte communications as I try to understand what's going on. And then we make a record with you involved as to how I processed all that. But as I said, if I learn from threshold disclosure that it's 10,000 documents, then I bow out of that. That's not a proper role for me. And I think that addresses both things, in-camera review versus special master. We don't do both. We do one or the other. The in-camera review doesn't occur if it's too voluminous.
Okay.
So I may not have expressed myself clearly at the outset, or I may be misunderstanding you.
I don't think so. I just wanted to point out that, well, what I said is what I said, so I'll leave it at that.
Okay.
But I guess I'd also add to what you just said, though, that I don't think it's either or on whether you disclose or don't disclose. I think redaction is also a possible option.
Sure. I'm sorry. The either or to me was right now special master versus in camera, but you're exactly right. There may be this document right here, and the part that's super sensitive is this paragraph right here. It's redacted, and then the rest ought to be disclosed. I think that's fully part of it. The fact that there are 3 sentences in a document that might be privileged doesn't make the entire document fall within the ambit of exempt from ORA disclosure. I agree entirely. I didn't mean to say otherwise. The either or was, I'd like to try to handle this via in-camera review. You represent a nonprofit organization, and the county attorney represents a government agency. So we don't have big budgets to roll around. This is Chrysler suing Ford, where like, great, we'll hire 15 special masters to do it.
No, I agree with that.
Okay.
So I think you said earlier in your preliminary remarks, what our big concern is we don't have any confidence in the universe of documents. I mean, you found in the order awarding attorneys' fees that they responded without doing a search, and then didn't even do a search until after the complaint was filed. They don't have any records of what they searched. They say they didn't search even the cell phones of the 6 people that they knew were involved in some communication or dialogue or something with the January 6th committee. And then when you ordered them to do, I think what would have amounted to like the 5th search, when they previously said they don't have any records at all, privileged or otherwise, now they say they have some records that are privileged. It's just very difficult to have any confidence. Oh, and they said they didn't know how to use the Cellbrite technology to do kind of forensic searches, even though
That's
they have
what they
that
do with-
technology and they presumably use it a lot. And
They do with every cell phone that they seize from a murder defendant.
Exactly. I'm sorry, I'm over here doing all of this shaking because I want to get them to get out. Most of y'all can hear what they're saying. But just like I said, this is ridiculous. From the beginning, he said a lot of this probably can be handled by them just simply redacting and getting the information out. But I think Fani is very similar to Tiffany here in self-destructive, because regardless, the information is going to come out. So by her doing all of this is just a ploy to me. It's just a way to delay it enough to see can she get back in the Trump case, and prove, I guess, what they were trying to prove. And I'm be honest, because y'all know I don't have a dog in the fight, but I'll be watching politics from the outside. I was like, when I saw Fani Willis go against Trump, then the other black DA in New York go against Trump, and then there was another black prosecutor, I think. I said, whoa, the Democrats done set them up to be lynched. And one of the ladies that went and had something against Trump, I got to get her name. They went after her for taking out money out of her 401k. I'll get her name. You know, I'm not the best with names. And they literally try to prosecute her for taking money out of her 401k, saying it was fraud because she exchanged money between her and her husband. Now, I'm bringing this up because there's a lot of politics going on. So I don't know if Black Girl Magic is like, I'm not giving up. We on a task for the Democrats and we're going to tear Trump ass, and to do all of this on the backs of the taxpayers. Because like I said, they don't need to have this. It needs to be enforced. Fines, just a good fine, because it's still on the back of the taxpayers or the DA office, because she tried to act like the DA office is a separate entity. Did you ever hear Fani Willis talk about that? Like, I don't have to answer freedom of information requests because I'm not that part of government. I just have to go up. I haven't talked about Fani in a while. I have been paying attention. She roused me up just like Tiffany, because the level of corruption, and then they use the black card, it makes me feel some type of way, because when the good people get in there, they got this brown color, we ain't gonna make it because of all the shit they done did. Let's finish play this.
Exactly.
Right.
So that tells me that there might be a technological issue. So we think a special master is going to be required for a couple of reasons. One is the horrible lack of confidence in their searching capabilities or effort that they're putting into it. And if they turn over the 55 documents to you and you say, yep, those are privileged, fine, we're done. Like you said, there might be 5,500 out there that they should have produced and didn't. And then because of the apparent lack of knowledge, at least with the people that do the searches, of using this technology that they have available to them, a special master might be needed to provide technological support. And the person you'll appoint as a special master then might have to consult with somebody else on how to do that. But
Right, probably the latter. I don't know that we'll get someone from Microsoft as the special master, but you're right. We'd want to make sure, if we get that far, that we are empowering the special master to know what kinds of technical questions to ask. But I don't view that as insurmountable. There are white collar investigation lawyers who are pretty savvy in that kind of situation.
Okay, so that's what I was trying to find out. Who would they appoint as a special master? I looked it up and everything. It didn't really give a job description. So it may not have to be a lawyer, as they say, and there's like a Microsoft technician. That ain't the one that's going to fit this case. They need to get a lawyer in here, because it's not just about the volume, possibly. It's about the ethical issues. Will this actually happen? How much will they release? So if you have a special taskmaster that may be a lawyer, a high-ranking lawyer, you, as far as being older in the game, you know what I'm saying? Because some lawyers, they act like judges sometimes. They play magistrate judge and all that type of stuff. Yep, girl, yep. Use that person. I think a special master or special taskmaster need to be, because if you took it this far, we got to do something to stop the waste, stop the bleed. This is bleeding the people money. So I think it's very important, just because the judge want to continue with this hearing process. You see what I'm saying?
I have every confidence we could find one or more people to do the job.
Okay.
But Rule 46 allows for a special master, and as you pointed out, it only says unless the statute provides otherwise. I don't think the Open Records Act provides otherwise. And the purpose of the special master would be to provide advice and information on technological issues related to discovery, which is one of the things we've got here. We've got basically what amounts to a discovery issue, and there's technology available that apparently isn't being utilized, and then also to monitor implementation and compliance with orders of the court, which is another issue we have, where the court has ordered a diligent search, and what was produced is the only one document that was produced was the one we gave them, so that didn't take much effort. And then we don't know, because of the many violations of the Open Records Act we've seen in the case, there's just no way to have any confidence that their search was thorough and productive and used all the technology available to them. So I think we need the special master, both because of technological issues and to monitor compliance with the court's order, because there's just
say moral issues, but they don't want to use that word because it's like defamation, and the judge be like, don't use those words. And yes, ma'am, Miss KJ, you're 100% right. I had mentioned that earlier in the live, so I don't know if I distinguished it right because to my audience, but this is her second Freedom of Information request lawsuit, and the first one had to do with the Georgia election voter registration. She wasn't given the board, the Republican board, their access to it. So that board member had to make a Freedom of Information request, and she was denying that ass, and they lost that one too. Yep, you're 100% right. So this is another one. Uncompliant. That's what, just uncompliant.
There's no way to know that, especially in this case, that there has been compliance.
Look.
Okay. Mr. Bowman or Ms. Thomas, I'm happy to hear from either one of you. What are your thoughts about how we ought to move forward?
Thank you, Your Honor. And to the point that you made earlier, we're looking at a universe of documents that we've been able to develop at this point. I don't have an exact number, but it's around 150 pages. It's not an excessive amount of documents. Not thousands. We won't be bringing in banker boxes or anything like that.
Have you had a chance to read any of the documents?
Yes, Your
All of them or some of them?
Honor. Been able to go through all of it, yes.
Okay. I don't want any substance in your response other than, yeah, it could be that way, or no, it's not. But one of the ways that I think I'll be able to address some of Mr. Monroe's valid concerns would be if one of the documents that you produce says, as we wrote in our letter from August 2, and in the universe of 150 pages, there's no letter from August 2. As you've done your due diligence, and I don't use that in a freighted way. I'm not suggesting you've gone through and made sure there are no overlaps, but when you looked through those documents, did you have any concern that, well, wait a minute, they're just internally, they're referencing documents that aren't part of the universe of what was produced, and so clearly something's missing?
Well, Your Honor, there were two items that I noticed that I followed up on and got confirmation that no documentation related to the two questions I had existed.
Okay.
All right. So I want to get to your question, which you said, how can she ignore the law? Is this an ethic violation? Most likely it's an ethic violation, and the court has the right to find as well. And guess what? The out here in Georgia, the ethical division that's over the judges and things, it's all a good old boy system. They won't look at your complaints. They will not. I mean, as far as the average person, and I'm saying that from literally doing it, like we have found no ethical issues. I said, but I explained to you that the judge was talking about going to the cookout with the prosecutors while we was on break. So, yeah, welcome to the South. Yeah, I'm so sorry, baby. And I live out here. How about that's why I stay in the house. Because once you get caught in the system, you got to fight. Thank you for your comment. I appreciate you for participating. Let's play this. 150 documents. You telling me 150 documents need a special master? You need? Nah, I mean for real. Okay, let's finish. I'm literally watching this live with you guys. Once I saw that this was on or it played, I said, cool, let's watch it together and let me give my raw reaction. That's what I really like to do. So let's finish listening because that threw me off. I'm like 150 pages? And we here for that?
All right. So in general, it was a fairly self-contained universe. The things that you received didn't lead you to say, well, gosh, this says 1 of 4 and we only have 1 of them.
Correct. Yeah, there was nothing that was certainly obvious to me that there was something that was missing based on what was provided.
Okay.
And I got an update that there's 212 pages worth of documents. I think some of them are duplicative, as multiple people may have been on the same communications and have provided that in the suite. But District Attorney's Office has recognized the challenges that were created in this case and has taken remedial measures as part of following up on this order to conduct these searches. And they had searches conducted that consisted of relevant email addresses of those involved in the cases and investigations that were at issue here. There were a number of search terms to try and capture the entire universe. There were over 50 search terms entered across the various people included in those searches. Some of the—
When you say searches, this is searching what?
This is searching emails in particular.
Got it. So if Jane Smith was someone who was represented to you to be someone who would have been involved in communications with the January 6th committee, then a search was made of her work email for the word insurrection. And anything that had that word in it, you would have looked at and it's like, oh, she was shopping in a strange place versus it related to whatever happened on January 6th.
Along those lines, yes, searches such as January 6th committee, January 6th, Jan 6th, Jan.
Okay, I don't need all the search terms, but I'm just trying to understand. It wasn't searching for her name in her own email box. It was terms that the investigative team, whether that's from the county attorney's office or a joint team of DA people and county attorney people, terms that would be relevant to the nature of the inquiry from Judicial Watch.
Yeah.
Got it.
And then physical files were also searched, as well as phone searches. I don't know about the Cellbrite technology. That's something that I can confirm. And if there is anything, if it hasn't been done, we can do it and provide it to Your Honor for in-camera inspection. If it has been done and didn't turn up anything, we'll inform the court of that. But there were significant changes, including the methodology used in the search from previous searches in this case.
What they saying, what he's saying right now, it's questionable if they did the search correctly. This is a little nerve-wracking and getting on my nerves because, like you say, it explains what we was talking about a little bit about what happened with the YSL trial. They could get everything. I never saw them have so many Instagram posts, dates, time. It was millions of articles of evidence that was taken from phone records, phone taps that didn't even have warrants issued, if you remember. So how can't you 150 documents that's in your possession? I'm over it. Y'all know I ain't over it, but I'm over her. I'm over Fani's office for real. And this guy, he's doing okay, but he's messing up, obviously. You see, he ain't got it. He don't got it totally. I can smell the lies. I can smell, how can I say, the untruths or the half things, so basically they did an email search. Let's see what happened when they put these particular individual names in or whatever. And I think it's some stuff that's missing. Excuse me. That's what I really think. I think something's missing.
Is your office involved in the searching, or what you're sharing with me is what has been represented to you by someone from the district attorney's office?
The latter, Your Honor, the district attorney's office conducted the searches.
Okay, so you're the vessel through which this is flowing. You're not the architect of the search. And I don't mean you personally, it could be Ms. Thomas or someone else who was sitting there saying, I'm going to type in this search term and see what emails turn green on the screen because of that search term.
That's correct, Your Honor. And the district attorney's office is also prepared and agreeable to the in-camera inspection and willing to provide those documents to Your Honor. And on that line, and because we are willing to do that, we do oppose the special master's request discussed in the briefing.
Hell no, we don't want no special master. We'll do the little camera thing, fuck up the camera a little bit, blurry up the screen possibly. But no. Listen to this fool.
Done a little bit today. It's not specifically included in the Open Records Act, but as Your Honor said, it's not excluded by the Open Records Act. We don't dispute the fact that the court does have the authority to appoint a special master in a case, but.
Right, I don't think it's, I mean, there may be some obscure statutes that say special master, but it doesn't say special master in the Title 13 on contracts, but I can appoint a special master in a contracts case. So I don't think the failure of the Open Records Act statutory scheme to say something other than prohibiting it, they could always say that, but it's intrusive. I get that. And it's intrusive into a sensitive agency. It's not a special master who'll be poking around inside the animal control building. So I understand the sensitivity of that. And I still view that as a second step that right now we're going to hold in abeyance while I see, I have some other thoughts about what's going to need to be documented from the district attorney's side to flesh out this record, but you should keep going.
Very good, thank you. And I definitely agree with I think all of that, Your Honor. And as you mentioned, just one of the things that we wanted to point out was certainly the burden that would very much outweigh the benefit in this case of, especially at this stage, appointing a special master.
When you say at this stage, like it's too late for a special master, or it's high time for a special master?
No, Your Honor. Just in particular right now, because we believe that the in-camera review of the documents will allow you to make a determination, and that, you know, the as we've mentioned, the size and the scope of the universe of documents here and what they'll reflect. We believe that, Your Honor, you are in a position and certainly have the ability to view that and review that and make that determination without outside assistance.
Yeah, shut up before you make him mad. Okay, because he's like, I can appoint him. You shut your damn mouth. Because it seemed like Fani said, this is what I want and this is what you're going to push. No special master, because if they find anything, we all going to jail. That's Fani Willis. Her office screaming from the top of her lungs.
And so based on that, I think that's kind of where we are. We're happy to provide the documents that we've determined for in-camera inspection and just, you know, kind of reiterate that we believe that they're not suitable for public disclosure, and they are subject to the exemption. And you know, there are a couple of cases that definitely support it, as well as the actual statutes themselves. You know, the statutes supporting being records of law enforcement and prosecution.
Well, I'll cut you short on that. I've never heard Mr. Monroe say there are no such exceptions. I think his concern has been, and he'll correct me, he's good at doing that, is, well, how do we know that? And it's kind of suspicious that you have no documents and then no documents because we didn't search, and then we did search and we have no documents, and then everything except what he gave the DA's office is somehow accepted. But if I'm making it up, but if they are all attorney-client privilege documents, they are all accepted from disclosure. To me, that's not the controversial part. It's developing a comfort level that they don't just now have a red stamp on it that says attorney-client privilege, that if we carbon dated it was affixed 2 weeks ago rather than when that document was generated.
I appreciate that, yes. And I think more than the privilege.
Oh. So I would assume, and I have to verify, I like that. So, excuse me, the judge is saying basically the attorney client privilege kicks in when you be a client, an attorney. So if they made the request before that, those documents should be available. If anything created after that, I would assume they would not be available, allegedly. That's what I'm getting from there. But every type, basically they're saying every spending or anything connected to what they're asking for is all only related to the case. I think it's more because it's going to show more waste and abuse. It's going to show a little bit more of how Fani Willis get down. So I think it's some things that may need to be retracted, but not everything. Because it may be, I know from doing freedom of information requests that sometimes you go do looking for one thing and they be all weird, black, 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 and then you find something else like, what the hell? Oh, let me freedom of information request this. So sometimes they know that things that will not be attorney-client privilege, that's what I'm thinking, will kind of like do a domino effect. Like you were saying, you basically saying if she comply, she's done, because they talk reckless. Okay, they talk reckless. Cops do reckless things. They do reckless things. You know, allegedly, according to the Alexis case, some of you don't know, we're pursuing something in Illinois. There was photos exchange between cops of the investigation and things that I don't want to disclose, but they are reckless, and that shit, it won't come out. Let's keep playing.
But it's both the investigatory aspect and the work product aspect that are the more prevalent.
Let's talk a little bit about the open investigation, because Mr. Monroe, I think, made the wise request of, hey, we don't want to have to come back here and do more litigation once the investigation is closed. Things that the DA has put into the bucket of open investigation, the bottom of that bucket falls out once an investigation is closed. That's in the Open Records Act. I don't know how much you can say or you know about the investigation. I don't know what makes an investigation open or closed. People have been indicted, and in some ways that closes the investigation because now there's an indictment. The investigation is over. We get in front of the grand jury indicts, and now there is a prosecution. So that's the P word, not the I word. And so we may need to do a little litigation around that. And that's setting aside the question of, and it may not even be this office that's doing the prosecution going forward. That doesn't mean that the prosecution is closed or the investigation is closed, then it's just a different entity. They might have the very same concerns. They might take a different view as to, but for now, we're getting the view of the prosecuting entity. But talk to me a little bit about what open investigation means in the context of a indicted case.
And Your Honor, the exemption cited actually applies to both investigation and prosecution in this case, and the documents we believe would also, in addition to being part of the open investigation, do still constitute attorney work product as well as part of it.
I see your point. No, there it is. It's exemption or exception for, it's any pending investigation or prosecution. And we call it open investigation for shorthand, but it is clearly a pending prosecution. It's an open case on appeal, but it's a pending prosecution. So I won't bug you about that anymore.
It could be both, and there's actually a case that talks about that a little bit, a 2015 case from the Georgia Supreme Court, Evans versus Georgia Bureau of Investigation, 297, Georgia 318.
He don't know what to say.
Okay.
And so,
look, he was happy that went good with the judge. You saw him like, okay, yeah, because Fani not being prosecuted. So y'all talking about Trump's? Ain't we asking for your records of your spending and what you did with your man? That type of stuff. So it's just giving the foundations of your investigation. Then and probably some of them conversations will come up with people she talked to in the White House and all of that. Y'all remember? She's talking to people in the White House, strategizing, saying she going on to the White House to strategize. She said it plenty of times without them having the freedom of information. Bias. Just bias. You don't need an email to find that. But let's keep going. he happy. You saw how he relaxed, like, okay, let's go.
With that, I think we're comfortable providing the documents for in-camera inspection and of course, with any directions that the court would want to provide on how to accomplish that.
Okay. I appreciate that. I appreciate the work you all have done. I hope Ms. Monroe, your predecessor on this, is doing well wherever she has ended up. Do we know where she ended up?
I don't recall exactly. I know she ended up, I think she's somewhere with the state, if I'm not mistaken.
Okay. All right. Mr. Monroe, you're as the movant here. Anything you want to say in response, beyond what you've already said, in response to Mr. Bowman?
A couple observations, I guess, Your Honor. One is, when you gave examples, you said 100 documents, you're fine with that. 1,000, you're not. Now we're hearing a number in between, so I don't know where that leaves you. 212 seems like it's a bit of work. I don't have any lack of confidence in your ability to look at documents and see if they're privileged or not. I'm not the least bit concerned about that. I'm not sure that you would have the ability to look at whatever they provide and have any more or less confidence in the thoroughness of the search done. So I think, I don't know how that issue is going to get resolved or go away.
I've been thinking about that, and I'm going to engage with you and Mr. Bowman in a minute. So we'll keep talking about that. What else?
That's all, Your Honor. Thank you.
Okay. I share your concern. And you were gracious in saying the court found X, the court found Y. Dexter Bond said X and Y. I mean, my findings were based on what the district attorney's deponent said. Yeah, we really didn't search the first time we said we searched, and so on and so forth. And I'm not pillorying him. He gave truthful testimony. But the facts of the case.
I just want to throw that out there. This would be a little bit weird, too, because this was the same judge that had the hearing before with her related to her being disqualified, right? Okay. It's the same judge, because it was a separate judge that did the other freedom of information request. It was the lady judge. It was all of that. I liked her. She was decent. So would he feel like a piece of if he see, because he's opting to go through the 150 documents, and it proves whatever he see that he won't be able to share, they have to determine if it's legal or not. He actually see that everything that they were saying was correct, and he should have just took all of them off of the case and stopped it. You think that's going to happen? You know what I'm saying? Because these judges are recycled and prosecutors, just like many communities. And as you say, I love the South, but you are right. It can be very saucy. The South is a hot damn mess. It is nice nasty, and I learned that. I'm from Jersey. Jersey, you're going to see a killer. Coming down south, they're going to be like, hey, ma'am. And you're going to be like, yes, sir. You're like, hey, right in the eye. In the eye. Right in the eye. And smile. And then cry. The victim. That is the spill out here. Okay, guys? Let's keep going.
Are such that everyone involved, in particular the lawyers who are now representing the district attorney's office, should be leery of a representation that, don't worry, we got this. It was 100% thorough. So I actually took solace in hearing Mr. Bowman describe in some detail the what sounds like the greater level of thoroughness of this most recent search. That said, my plan, to be modified by your input in just a moment, is to enter an order that indicates what we're doing next. And it's going to direct that Mr. Bowman or the county attorney's office get to me the 212 pages, et cetera, and any cover documentation that might help if they've been given notice by the district attorney's office. These pages go into the open investigation bucket, and these pages go into the work product bucket. And it may be that there's a document that goes into all three, and that's fine. It doesn't need to be mutually exclusive. And you don't need to do that, but it will help me I may look at this and say, there's nothing privileged in here at all. And if you were stuck in the room with me, you'd say, it's not privileged, Judge. This is work product. So it would save some back and forth, although I don't mind having back and forth, if either you've categorized them through your review or confirmed you agree with that, that you're sort of affirming the district attorney's designation, or if they've done it. It doesn't matter who has designated it. That would help. But I intend to enter an order that says I will perform an in-camera review, but I would like to also include in that order some details, or maybe in the order direct the county attorney's office to provide an affidavit that would go into the record that details some of the specifics of the search. I think that we ought to have an appendix to an affidavit that says these were the search terms. I think that's relevant because Mr. Monroe and his client could read through that and say, why is the word Trump not in there at all? Or the word, the name Jack Smith, and maybe there's a good reason why, but there could just be some things that were overlooked. It's been 4 years, and yet here we are still at this. And so someone may not have thought of something that was germane at the time. And I don't think there's anything sensitive about it, but there may be, which is why I'll let you flag something. That here are 99% of the search terms that can be filed in the record. Here are the 11 that will disclose in confidence or in camera, and I'll figure out how to disclose to Mr. Monroe if I'm going to do that. But I think search terms would be helpful. I think a description of how the search occurred, and I need to be clearer in that, but it would be the work emails of people involved with the investigation were searched using these search terms. You mentioned physical files were searched. I don't.
So if they do this, like you say, it's going to show everything. It's supposed to be each department that go in and bring up the information. So he's basically making it more thorough as far as finding out how the records were retrieved. But I think Judge McAfee is putting himself in a situation where he may feel compromised because he's going to see some shit, I think, that he ain't supposed to see. Okay. And yes, Ms. K, listen, it's so crazy because I moved from Newark, New Jersey. In Newark, they say you don't come to visit Newark, you just drive through. And if you stop, you ain't gonna have no tires. And you said that's a shame. I did see a comment made on live stream where a person said that people in this county drive around Fulton County, never through it. Yeah, you ain't gonna go buy no drugs, you ain't ready to be turned up. They got things down there, like they have, like I think of like a event center down closer to that area where people could get down, because Atlanta's like a circle. So Fulton County is somewhere around a circle, and it's just a little bit complicated. But yeah, pretty dysfunctional. Thank you guys for participating. It's a little bit ridiculous, but I think this is going to make it worse for Fani. I think it would have been better if he had a special taskmaster, because maybe that taskmaster ain't subjected to what this judge already heard. So as he looked through it, through the camera or whatever way he going to view, I know he going to see something. Mark my words. This may get very, very interesting later on in the future.
I don't know exactly what that means. I know generally I'm envisioning a manila folder open and you flip through it and okay, this is an invoice. That's not interesting. Oh, here's a letter from Jack Smith. That's got to put that in there. But some description of here are the steps that were taken beyond Dexter Bond walking down the hall and say, hey, anyone have anything? And he said, I didn't hear anything from anyone. And it turns out he did that Saturday afternoon. But something that would allow Mr. Monroe an opportunity to do what he's good at, which would be to pick at and say, I hear you, that's great, that's 100 search terms, but you're missing these 5. And then I'd be in a position to say, we ought to search under those, or you know what, Jack Smith versus Jack Q. Smith, I'm not gonna make them run it again because they didn't include his middle initial, because they would have caught Jack and Smith, and it doesn't matter what the middle initial is.
Be afraid.
But I think that will help me, and I don't know whether it will help plaintiff, but it will help me be more comfortable that we are finally getting closer to.
Don't beat my butt, y'all. I know I don't got the best color screen, but you watch his face. Missy, she holding the wood face because you know she part of the Fani Willis crew. Them got the wood face. just like love, okay? But him, his collar getting tight, his face getting red, because this is more thorough than just doing a camera review. Watch him. Let's see how beat red his face turned, because I'm watching the pressure go up. What's going on here?
The type of search that should have occurred way back when the Open Records Act request hit that portal, and that poor county attorney person who had to have her name on all these things saying it's all good, even though she didn't do any of it. It was the DA's office that didn't do any of it. And she had to have her name associated with that. So I think that's what I'd like to do. And I would invite and welcome input from you, Mr. Monroe, as to what you'd want to see in that affidavit or filing that would come from the county attorney's office, detailing what was searched. It may be whose accounts were searched. I don't want to get too many names out in public as to who's investigating what, given what's been happening to FBI agents who were involved with January 6th. But again, there may be ways we can make clear that it wasn't one email account that was searched. It was 27 that were searched. And the more that is done, the more of a hallmark of thoroughness that we see there. So do you want to take some time to think about it, and then you can
write it down?
People don't need to keep filing things. You can send an email to me copying Mr. Bowman and Ms. Thomas saying, I think it would be helpful to also get some information about this aspect of the search, if they even did that, because it may be that there's this description of what they did, and then your observation is, why didn't this kind of search happen as well?
Yeah, I think I'd like to do the latter. Consult with my clients. They do a lot of open record stuff all over the country, so they live and breathe this every day. So I'd like to consult with them about it.
Okay.
I do have one concern that I'm not sure you can address really at this stage.
And you remember his client is Judicial Watch, so that's what the hell they do. He said, "Cool, if the judge gonna let us ask like those particular questions, where it came from, I'll talk to my client, because we ready. People who do these freedom information requests, we be looking thorough. So go ahead, baby. This is gonna be good. We got less than 10 minutes on this. Thank you for being here for Grace Levi on Censor Enlightenment Talk. You know what we do here. I know a lot of you guys have been watching it because y'all have watched the other lives that we did, and y'all watch all the other amazing content creators who've been on it, like Kryptonite. So thank you for joining us on this platform. I do appreciate you, because I love this shit right here. I don't love the crookedness, but I definitely love to expose it, talk about it, and get us prepared to drive around Fulton County. Didn't I tell you? I kept saying, do not go through Fulton County. You're liable to go to jail. And we're going to do a little update on the jail, because it's the total opposite of what I told you before, where they were supposed to be empty in the jail. They shucking and jiving and bullshitting the people. But let's finish this real quick.
But Mr. Roman said that all of the searching was done by the DA's office. And I mean, maybe that's okay, maybe it's not. But in my experience in other civil cases with some kind of intensive electronic discovery, usually the attorneys are pretty intimately involved in that, kind of directing it and making sure that what got searched was the appropriate thing to search. I'm troubled by the fact that we're still leaving the DA's office to its own devices on how to do the search, especially with the track record.
Sure. I appreciate that. And it may well be that after I've had a chance to look at the 212 pages, and you and I both.
And at first they said 150, right? And I was like, maybe the judge messed that up. The number increasing. Go play it back when we finish. They said 150 because I wrote it. And then it turned to 212. Watch, there's going to be more documents.
Are able to process what's submitted through the county attorney's office about the specifics of I'm going to call it the search protocol, things that were done to yield these documents. That a step that I direct is that Mr. Bowman needs to go in there and hit go on the search as well to confirm that that's what comes up. I'm not there yet, but you are not being conspiracy minded in my mind to say it's a little odd that we're suddenly saying, okay, on the fifth go around, they meant it when they said, no, we researched thoroughly this time. So you should continue to be the skeptic and voice that skepticism. I'm trying to help everyone paint the picture of what does this latest effort really look like. And it may in the end satisfy me. It may leave your client unsatisfied, but that's where client management comes in, or an appeal, or whatever. But we're not at that point yet. I need to go through the documents, and then we need to get that submission from the county attorney's office after you and I both have had a chance to think a little bit more about what do we want that affidavit or whatever it's going to be to look like? What are the contents? What were the search terms? Whose accounts were searched? Again, balancing, I'm going to call it privacy interests. We're all public. You're not, but we're all public servants. But there are reasons to be careful about the identity of public servants right now who were doing what they were told to do by a superior. And in the eyes of some right now, that was treasonous activity. It's unfortunate that that's how it's being cast, but it's going to make me be careful about not how we disclose disclosable information, but how we manage the process of describing who had a role in the investigative work that was going on. Okay.
All right.
Anything else you want to add?
No, thanks.
All right. Mr. Bowman, anything else?
I don't believe anything further.
He like, hell no. I got to go back to Fani and she about to yell. Oh, hell no. This wasn't in his plan. The detailed research. Okay, y'all don't have the special taskmaster here, but y'all going to have to list every single thing, how you did it, where'd you go, who you contact. If anything is questioned and this continues, those people will have to be subpoenaed. Oh my God. This ridiculous. And yes, thank you, Status Quo. I'm grateful for you being here because I know we want to hear your thing. But motions do increase the binder content. But they said 150 to 212. 62 pages. Oh, shit. I bet you be some more. It's more. Then I went to Washington. They were sending love. Did you hear how many texts was between Fani Willis and that guy? They was on, man, they was on Talk Street. So I know they was reckless up there. They reckless. Yeah, I promise you. We're going to follow. I really believe that is way more. And I think this judge is going to feel away because he's going to be in the middle of it. Not that he's going to be responsible, but I think he's going to see something that probably make him upset. Let's see. I'm making a prediction here, guys. Let's finish this. I think we're done. He's about to dismiss them, and we're going to give you an update on Fulton County Jail.
Have I said things that leave either side with a lack of clarity as to what's happening next? Because I don't mean for that. I know it's a little bit amorphous because you want some time, Mr. Monroe, to consult with your client and flesh out, here's what I, meaning plaintiff petitioner, would like to see in this affidavit describing how the search was conducted. I'll enter an order that says I'm taking this under the 212 pages in camera to review that. So that's in the record. It's in the transcript right now, but that ought to be demarcated on this date. County attorney, you got 4 days to bring me the documents, or 48 hours, or whatever it is. And then we'll all know where those are, because if I get distracted by something else that maybe happened in 2024 and there's someone sitting in jail, then you'd be able to say, Judge, you've been sitting on only 212 pages for a month. That's 12 hours a page. Let's go. And I'll say, you're right. I got to turn back to that. But at least there'll be that marker saying, here's where we are in the process. Anything else you want me to be clearer on?
No, I guess I just observe that I know the defendant in their brief said that a hearing was required before you do an in-camera inspection, but then in their brief they also said they would consent to one. So I just want the record to be clear that if there is any hearing requirement, they've essentially waived that so that we don't have that issue come up later.
Okay, well, we're having a hearing now. It's addressing the in-camera inspection. I don't think I need one for an in-camera inspection. I think I need one for a special master. You pointed that out. Rule 46 says I can't appoint a special master without a hearing. I'm not appointing a special master right now, but we've had a hearing on both topics. And I find
it's going to be a lot. We're going to have hearing after hearing, and you're 100% status quo. It's going to add to the damn paperwork. So he like, can we just basically skip over the hearing? And judge like, well, no, we got to have a hearing because, It's going to be more tax dollars paid out. You know, it is what it is. No, he ain't say that, but y'all know what it is.
That both sides have had sufficient time to resist the concept of an in-camera review or to support it. And I think we're at a point right now where everyone is agreeing, okay, the next step will be an in-camera review. You are not waiving, Mr. Monroe, your efforts to have a special master involved.
No.
And you're not. I'm telling you, you're not. And I remain open to that concept. This is a graduated approach. If I look at the 212 pages and am grossly underwhelmed and it's just patent that there got to be other things out there, then we're done with the DA telling the county attorney, don't worry, I've got this. And we bring in the professionals.
It's going to happen, y'all. We're going to be able to keep it up to date with this. This is going to be good. Fanny about to lose her job. She gonna lose her job. I'm praying on it.
That will be messy, and so I won't do that lightly. That's pretty complicated. I don't mean technically complicated. It may be. I won't have to be involved with that, but it's intrusive.
Y'all heard what he said is gonna be messy and intrusive. He already know. That's why I don't know why he's taking this route. He just needs to find them and force the ethical board to get on her to take himself out of it. But nah, he want to be part of that. I like this is Doug McBurney. Let me just make McBurney, right? I like him, but he tripping a little bit. Like he keeping himself inserted too much, I think.
And hopefully everyone's been thinking that is the least good outcome. And so this search was thorough, but we'll see. So no options are off the table. This to me seems like the reasonable next step, in particular because it's 212 pages and not 2,120 pages. So we'll see. Anything else on behalf of the district attorney's office?
No, Your Honor. Other than in addition to 212 pages, what we will do is also follow up regarding the cell phone issue that was raised, the particular technology, just to ensure that was completed, or if it was not, that it is completed.
Good.
So I'm not remembering your answer. Was your answer cell phones were searched, but you don't know if it was Cellbrite, or you don't know if cell phones were searched at all?
That's correct. It was cell phones were searched, but I don't, as I say today, I can't tell you whether the Cellbrite technology was used.
Okay, got it. Understand that. The documents that you'll be getting me, is it going to be a thumb drive and I'm looking at them on a screen, or is it going to be a Redwell and they're printed out?
Whatever the course of preference is.
It's really you and your clients. I don't know if they prefer that it's hard copy or they prefer that it's.
Now you can see Judicial Watch lawyer. He doing great. He a little annoyed because they still giving him too much. Okay, how I'm going to receive the judge was like, we need it this way, so it could be the easiest. He's a little bit too, liberal for me for this case.
It's on a thumb drive. Obviously, it stays under lock and key, and whatever I conclude ought not to be disclosed. We may agree I'm going to file under seal in the record because there could be an appeal or who knows where this goes. But I defer to you and your client's decision. I was just curious how and you may need to talk to them about that.
At this point, I believe it'll be hard copy, but we'll update you.
Okay. All right. And any issues with legibility as you were looking through it? Nothing is like a copy of a copy from a napkin?
I don't believe so. There might have been a couple pages that were a little bit light, but nothing that I found to be illegible.
Okay. Sounds good. All right. Well, if there is nothing else, I'm not sure who
let's pause this.
Obtained Ms. Taylor's services.
Judge Robert McBurney. So I'm going to put all the information of whatever we show you. You know what I like to do, even the Law Institute as well as Judicial Watch. And I'm with you. I don't know why they think that we suckers. And I'm not part of Judicial Watch, but just the common person. Once we move forward to handle motherfucking business, it's like we going all out because we ain't under your watch. And that's why I said we the people have to build institutions and generate the money and the resource and the expertise to do things like the Judicial Watch and the Law Institute that I showed you. Because I'm going to be calling Law Institute about these speeding tickets. Now, this house stuck on, shut up, y'all. I'm out in Atlanta, so I could say it. I'm going to talk. Y'all talk about shit, the truth. People be mad. Stuck on stupid Atlanta voters are, or whoever still voted for her. I think too, what plays a part is that people don't want to have shit to do with this system, so the voter turnout be very low. And these politicians, whoever going, they rally up them people, rally up their people, and it just be a little circle thing going on. You see what I'm saying? Let me just remind y'all that this motherfucking broad, we talking all this stuff about her. She just won to get right back in. This just today years old. No, I'm lying. Let's play this real quick so y'all can see how much crazy Fani actually won out here in 2024 after she ran after Trump, after it was already exposed about her and her boyfriend. Look at this shit. Okay. Now, this is a two-tier. It's the voters and also the Republican. Courtney, this lady wasn't standing a chance against Fani for some apparent reason, even just the way her mannerism and demeanor was. And you know, it's a mostly black area. So I think they need to have somebody who was a little bit more down to earth, a little less stuck up, and, you know, more like Merchant. You know, Merchant, like, I ain't stepping back to this shit. I'm above this. But somebody like Merchant, or I don't know, another Republican, could be a black woman, whoever black, but she didn't fit. So I don't even know how. I was about to call her Hinyard. I was just about to call Fani Hinyard. I don't even know how she won, but let's watch this real quick because we stuck with her for some more. I don't know how long because I hope that she go to jail, but I'm gonna say for some more.
Your local results tonight in the race for Fulton County District Attorney, Fani Willis projected to win re-election as the county's top prosecutor. She defeated Republican challenger Courtney Kramer, who worked in the White House in 2018 during the Trump administration.
Hey, we want to check in now with the 11 Alliance Grace King. She's live tonight from the Fulton County's election hub in Fairburn. So, Grace, how's the count going now?
Wait, I'm gonna stop right there. What? Okay, y'all saw what she won by. What? Give me the mess. Wait, is that the thing? Some of that gonna be coming out? You said, and Fani used part of the jail budget to prosecute Trump. No result. Oh, we're gonna look at the jail because the last update that I did, go to my Atlanta news section. I was hitting the jail. Oh, it was at least 21 deaths in 2008, going into 22, 23 into 24. And we were just banging on it until they stopped really reporting them. But I know it was a lot. The conditions was terrible. They were making makeshift weapons. Like, I still got the picture because I knew I was going to be coming back to this year. That's all that shit. Right there, the picture at the top was when that was the picture of the man that got ate up by the bugs. So that jail is beyond being named condemned. Y'all remember that the contractor police that they had not only was bringing contraband, making babies with the prisoners. They had walked out on the contract. These are some of the updates before she won the fucking election again. Yeah, they walked out on the contract saying that it was just basically known in a setup that they wasn't going to get paid. So they walked out, and mind you, these was unarmed officers. Like, they literally had security guards in there being correctional officers. Baby, the jail is beyond messed up. Y'all remember one of the YSL defendants, Cody's stabbed up. And what Glenville do? Move right the fuck on. Like, we're gonna take one day off. He's okay. Yeah, we're gonna come back. They don't give a damn. They don't give a damn. So all that being said, and I still got way more because I remember it like, but I ain't gonna do it. DA Fani Willis calls for funding for jail. For the jails. This is January 13th. This she lost her mother mind. She lost all her fucking cheese and bread. Cheese and fucking bread. The jail has to be shut down. It's condemned. And you're going to see her big mouth. I have something about this woman that make me mad. Let's play it. It's a spiritual thing. Y'all, she's messed up.
He's such a Southern gentleman, right? Fulton County leadership. We
see that face? Such a Southern gentleman, right? Rocka! Stab you in the face. Right there. That's her.
Need the Fulton County Commission to do their job.
See?
The reality.
Stabbed him right in the face. Right? I just told y'all. He's such an amazing face to look at. But I'm going to need him to do his job.
The reality is the sheriff cannot do his job, nor the district attorney hers, if it is not financed properly. we have known for years, and the sheriff has been begging for years. The jail is falling apart. The prisoners are using pieces of the jail to make shanks to hurt other prisoners. We know that. Atlanta has done their part. They gave us a facility. They've helped us in the way that they can. This is not on the mayor's shoulders. It's not on Atlanta Police Department shoulders. It sits on Commissioner Rob Pitt's shoulders. And we ought to demand that they have humane conditions. We ought to demand that the DA's office is financed in a way where we can properly prosecute crimes. And citizens ought to call and say, we don't want people to live in these.
Hold on, y'all see me. Y'all know me from my Hinge broadcast. Y'all see my face. I couldn't even help it. Oh, she won't take no responsibility. And she's such a stickler that some of these people are locked up for like, you know, it don't involve murder. It is not victimless crimes. Let's say that. They're victimless crimes where these people are still sitting in this jail. So to answer that question, because you brought it up, like, damn, they still sitting there for years and all types of shit. We're going to do our research. But I know they still got a good number of people that was there over 3 years, 4 years. And the one that was there over 7 or something, allegedly they're blaming it to the mental capacity. And there ain't no rehabs here. So they just going to indefinitely hold this month. I don't even know what happened to my man right there. But let's see, can we keep y'all up to date? And we going to keep hearing this hag talk.
Inhumane conditions. And he gave it to you lightly. I've been a district attorney and a defense attorney. The jail is disgusting.
So if it's disgusting, I'm sorry, I got to get at it. If it's disgusting, why didn't you keep the pilot program that y'all was allegedly doing, transferring the prisoners to adjacent jails, not outside of the state, because that'll be really hard on the person in jail. But that's what they were doing. Guess why they don't do that? Guess why? It's not just his funding that they want. They want the federal funding and the private funding. Allegedly, like BlackRock funding, and I'm gonna shut the hell up. You know, these places that sponsor private jails. Why would you want Fulton County Jail in the middle of the most active city in Atlanta? Give me the money, yeah, so I can pay my baby with his bald head, allegedly.
If you go in there, people were sleeping in pods. The conditions should not be that way. You have one man manning 50 and 60 inmates. That cannot happen and people be safe. And so at some point, we have to put blame where blame lies. And where it lies is with Chairman Rob Pitts and those 6 commissioners that sit with him. And they have a duty that in 2 weeks, they need to issue a budget for our sheriff and for this district attorney's office that does the job.
I'm pausing right there, y'all. It's a little hard for me to get through Fani, so I'm gonna be really like, oh, hurry up, shut up. What really make me piss is the gaslighting for me. If you are concerned about the conditions in that jail, why are you locking up victimless crimes like people who have speeding tickets and things like that instead of sending them the fuck home and then bringing them back through the court system? You're keeping them in there. You kept one little girl in there and they killed her with allegedly anxiety medicine because she had trespassing on the school ground. And she was like 21, you know, older young people who like to be around younger people. I don't know what the hell she was doing, excuse my language, but the young girl died in the jail because she probably was going off, acting like a fool, knowing she wasn't supposed to be in there for trespassing that long, 5-6 days. And you got some fucking nerve to talk about. It is horrendous. It's gaslighting for me. Because you help fuel those conditions and you're packing people still in there under the guise that you have to clean the streets up. One more thing, highlighting. Do y'all remember where it was a young lady that basically came to a hearing in front of the Congress or state representative of Georgia, because that's when they wanted to have like basically put a law in Georgia, just like out there in Illinois, to get some of these public officials, like, you know, taken out of their position when it came to district attorneys. Okay. And in her particular hearing, she was basically saying that during Fani Willis' first transition, they had a gang and task force unit in Atlanta. That's when they knew that the gangs was getting bad and they were trying to do things to redirect the kids before it got bad. But when Fani came in, dismantled the system, the program, fired the lady, put her in another program that had nothing to do with her specialties, because this lady was from the city. And I remember it. She was from a city, like, I always refer back to Newark. It was a gang infested city, and she already was acclimated to how to deal with it, had programs, and they was bringing it to Atlanta before all of this blew up. She knew what was going on, because y'all remember Fani Willis. See, I'm coming out the bushes. Fani Willis, I remember, was the private attorney to one of the YSL representative. You know who I'm talking about. The one YSL gang member that didn't get indicted. His name is at the tip of my tongue. Okay, he came out, had an interviews, and say, it was kind of weird, because I was like her last case before she went to be DA, and then wonder why people went to her house and protested her. That's why, because people saw how she moved on the street, and they knew, in my opinion, that she had a lot of ties to the street. That's why she was able to pull together in garbage pieces that YSL case, because she had bits and pieces, allegedly, according to my street knowledge, because I got them young people out there. And from what I saw, she had bits and pieces of what was going on in the street. And all she had to do was get the evidence to put the shit together. That's what you saw, a product of that YSL trial. She made that. We still don't have any programs out here that is really related to gang prevention. She switched that program and made like a scholar type program. I forgot the name of it, but it targeted kids. It was like a summer program, and she was bringing politicians, nieces and nephews from other states on the buck of Fulton County, instead of giving it to our black youth, our low, we going through it. Anybody live in Fulton County? No. Black, white, whatever. Shit, it ain't no joke. No programs for nothing. Those fucking kids just literally drive around just starting shit, running around looking for trouble. No, I mean for real. Like, because my son is in the age group with them and we be talking. They literally just drive around and they're no reason at all. And they got the pistols. They got the long jacks. They got them shits that you put across in your book bag. When you see somebody with a book bag and it look like kind of Abalong, I'm like, oh yeah, he got the. This is shit that's walking around Atlanta right now, because you know this open carry state. Yeah, we dealing with a lot over here. So I'm gonna get back in the game, talking about Atlanta, talking about these court hearings. If you don't know, to the new people who I'm starting to see, Miss KJ, thank you for being here. Status Quo, thank you for coming in on another subject. I appreciate you, because I know you like that law stuff. Appreciate your insight. Jerry as well. This is what we're going to be doing. We're going to be adding our insight, yours, and the things you knew, because y'all put me up on some stuff too. I'll be like, what the hell just happened? We're going to have some fun, crack some jokes, learn some shit, and expose what the hell is going on. Okay? Just remember, y'all, this is an open platform for everybody. We deal with politics, but I don't have a side. So I may say things that you don't like Republicans, and may say some things you don't like Democrat, but guess what? Grace like Levi, me, I'm on the side of God. And that's all I care about. So until I see y'all, hit the like button. I love you. And thank you for being here.
Answer. Because you are that, you are capable. You are gifted, and you are soon to be opinionated. It's okay to be different. And it's so okay to just be. The world awaits to receive you.
I could not be here breathing and be comfortable if I was really as bad as they was making it. You know, nobody could be around me. So for me to be this calm, I must have some kind of inner peace. And my inner peace is knowing that once everybody take the time to really see what type of person I am, you'd be surprised that I stuck around this long. I have to make the life that I do live as happy as I can and try to do the best with what I have. You know, live the best life I can live, be as happy as I can be. Nothing is perfect for anybody. I don't.
Boys, I swear, I think I figured it out. You know why they don't want us redneck brothers and sisters and the hood brothers and sisters getting along? You know why? Because we'd be unstoppable. I'm telling you right now, we would shut shit down.